In this installment of Washington Legal Foundation's Legally Brief, John Fletter, a partner with the law firm Hyman, Phelps, and McNamara, explores whistleblowers' use of Federal False Claims Act in drug promotion cases and several recent federal court rulings that affect such legal actions.
Many businesses are concerned about what some may call the corporate economic equivalent of terrorism, namely whistleblowers. Disgruntled former and current employees have a variety of legal tools to obtain redress when they believe they have been wronged. One powerful weapon used by them is the so-called qui tam provision of the Federal False Claims Act, the FCA. An individual who brings an action, called a relator, is entitled to share in any recovery obtained against the defendant who has allegedly submitted a false claim to the federal government or caused such a claim to be submitted. Any qui tam action puts the defendant company in a perilous situation. The action is filed under seal. However, the Department of Justice is provided with a copy of the complaint. The Justice Department then frequently undertakes an investigation of the defendant. Many relators have alleged that FDA-regulated companies have caused false claims to be submitted to the federal government based on the defendant's, quote, off-label, end of quote, marketing and promotional practices. The relator alleges that the drug manufacturer caused pharmacies and or others to seek reimbursement under some federal program for a product prescribed for uses other than the FDA-approved use of the product. A 2001 court ruling in Massachusetts provided much of the impetus for what has been a splurge of FCA off-label use cases. However, over the last few years, courts have been dismissing FCA off-label use cases. The courts have concluded that the sine qua non of such an action is that a complaint filed by a relator must specifically identify some, if not all, of the allegedly false claims submitted to the government, even when the relator, who is often a current or former employee in the defendant's sales or marketing departments, presents detailed allegations of the purported off-label use scheme. Because such a relator had no personal involvement in the claims process, that person usually has no knowledge of how claims were submitted. Of course, that burden is made much more difficult when, as is almost always the case, claims are submitted by a third party, such as a pharmacy. The leading recent case is United States ex rel. Roast v. Pfizer, Inc. The relator alleged that the defendants had engaged in off-label marketing of the drug genotropin. The First Circuit ruled that the complaint failed to satisfy Federal Rule of Civil Procedure, Rule 9b, concluding that the complaint, quote, amply describes illegal practices in which Pfizer allegedly engaged. But those practices, while illegal, are not a sufficient basis for an FCA action because they do not involve claims for government reimbursement. As presently pled, the complaint does not sufficiently establish that false claims were submitted for government payment in a way that satisfies the particularity requirement, end of quote. The most recent case is United States ex rel. Hopper versus Solvay Pharmaceuticals, Inc. In September 2008, a court in Tampa, Florida, dismissed a case where the relators, former company sales representatives, alleged that the defendants had used illegal off-label marketing practices for the drug Marinol. The court noted that the relators had conceded that they had no evidence of a false claim. As a result, the court followed 3 binding 11th Circuit decisions that held that a qui tam action fails to comply with Rule 9b unless it alleges the particular false claims submitted to the government. This is true even if the relator describes in detail a defendant's alleged scheme to defraud the government. Speculation that a false claim must have been submitted to the government was not enough to pass the Rule 9b mandate, according to the court. There is also a second large hurdle that qui tam relators have to overcome. A court does not have jurisdiction over an FCA action where the allegations are based on the public disclosure of allegations from an investigation unless the person bringing the action is an original source of the information. A public disclosure can occur, for instance, during a government investigation when the defendant produces documents to the government. A recent Supreme Court decision sets a very high bar for relators to overcome to establish that they were the original source of the allegation. Even if a relator brings a matter to the government's attention through the filing of a qui tam case, a court will have to scrutinize the particular matters raised in that case and compare those allegations to the court's findings that a violation has occurred. If, for instance, a relator discloses to the government that a company has engaged in a fraud in several respects, the relator will not be deemed to be an original source if the court rules that the defendant engaged in a fraud in some other respect, even if the government would probably never have investigated that, quote, other respect, end of quote, but for the relator's complaint.